Good morning and welcome. I think we're expecting a few more people to join us, but we'll make a little start. Um, my name's Alice Reeve, and I'm joined today by my colleagues Jo Oliver and Rebecca Fox. There are a lot of changes happening, or just happened in April in employment law, and so we thought this was a really useful time to just take stock and to run through those to make sure that you're aware of all of them, but also if there have been any questions that have arisen as you've been looking at the new changes or looking at implementing them, then there's a good opportunity to raise those now. We will be sharing a copy of all the slides, so all the detail that's on the slides will be with you, as well as a copy of this recording. If you do have any questions, please do pop them in the Q&A box as we go. We're going to answer them all at the end, so but there should be plenty of time for those questions. If you've got any technical issues, please pop it in the chat box, and my colleague Tamar is keeping an eye on that, and she'll be happy to help you. So in terms of what we're going to cover, we're going to start by doing a quick run through all the spring 2024 changes, so all of those that we've seen in April. We're then going to look a little bit further ahead, so those are on the short-term horizon. Some interesting cases that have practical impact for you, and then some developments that you should perhaps be keeping an eye on, including some landmark cases where we're expecting judgments. So moving to the changes. On this slide, there's a snapshot of all the things that have happened in April. We're going to run through each of these things in a bit more detail now, so I won't read them all out, but hopefully having them all together in this way can act as a bit of a checklist for you to check that you have gone through them all. But I'm going to move on to start at the top of the list and talk about rates and limits. Please don't worry, I'm not going to read out all of these because I appreciate quite how tedious that is, but I always think it's quite helpful to have all the current rates somewhere as a reference guide. So to start with, the top section is about the national living wage. We'll have seen the standard living wage go up from £10.42 to £11.44, so quite a significant increase really. And as well as the rate increasing, you'll probably be aware that they've removed the lower rate for employees who are 21 and 22 years of age. So now anyone from 21 up gets the £11.44 rate. So the difficulty with the living wage is that it increases in April each year, which is probably out of line with your normal pay review process, which I'd anticipate happens over the summer to take effect in September. So you do absolutely need to run through those employees who are whose wages would drop below that £11.44 and make sure that they are all receiving at least that as their statutory minimum amount. And yeah, it's worth noting that the terminology is rather confusing, but that national living wage is the statutory minimum amount, and it's not everybody needs to receive at least that, and it's not the charitable real living wage level, which is higher than that. I think one of the questions we always get asked is about the pay differentials, and if you need to maintain those for individuals who are on rates at or above the living wage already, but would ordinarily have been paid, higher than those on the minimum level. There's no legal obligation to do that, and you may, whether you choose to do that as an organisation is entirely up to you. You may wait and see what the budgets look like, and that could be something you address later on, perhaps. In September would be one option. I think what we're seeing as a general rule is that there are an increasing number of people in employment who are on that minimum rate, and so that's affecting the recruitment and retention challenges as well. The bottom of the slide, the rates for the sort of statutory rates for statutory sick pay, statutory maternity, paternity have all gone up, and so they are captured there as well. We've also at this time of year seen an increase to the week's pay figure. So that's now gone from £643 to £700. So this is the statutory cap week's pay, which is used most commonly in redundancy payments. So in a redundancy calculation, you'll be aware that there's a multiplier based on someone's age and length of service, and it's times by their actual week's pay, but that's subject to this cap, which is now £700. So you will need to think, if we've obviously seen a period where most of our clients have been doing some forms of staff reduction, looking at running as efficiently as possible, given all the challenges that we're all aware of on the horizon. And so if you have been making redundancies and you've issued notice, which will take effect 31st of August, you will need to check your redundancy calculations. And if their actual week's pay is below this level, you're fine. But if you've gone up to the statutory cap, you'll need to use the £700 figure. So do just double check that. The week's pay also impacts, as well as on redundancy figures, in relation to basic award if somebody brings an employment tribunal claim. And we'll see an increase into that, but also into the cap of compensation that somebody can receive in an ordinary unfair dismissal claim. So if they are successful in an unfair dismissal claim, they get their basic award, that's like the statutory redundancy element, and then they get a compensatory award based on their actual financial losses, but that's capped at either a year's gross pay, which will be the figure for most employees, or up to a maximum, and that maximum is now £115,000. £115, quite a hard thing to say. It makes me feel old when I see that, because when I first started, it was below £12,000, that figure. And so it's really significantly transformed employment disputes. And obviously there's potentially quite significant compensation on offer if people have been unfairly dismissed. You'll remember, of course, that there are lots of cases where those caps don't apply, particularly in discrimination claims. And in discrimination claims, as well as receiving compensation for their financial losses, individuals can also receive a separate head of damages for injury to feelings. And those awards are based on 3 bands known as the Vento bands, and those are on the bottom of this slide. So depending on how serious the incident is, or if it's isolated, there'll be a lower band award. For the medium cases, which usually include if there's been a sort of a discriminatory dismissal, it's the middle band. And for those very serious cases with causes of conduct, it's the upper band, and it's only really in very, very exceptional cases that a greater award than that will be given. So you'll see the figures there set out, and again, they're really quite significant now. And so I think what that means is that even where individuals are perhaps on fairly low pay, or even still in employment, they can decide to bring claims if they consider that they've been treated less favourably and suffered detriments whilst in employment, because the compensation awarded will be at those levels. I'm going to move off rates now and talk about holiday pay. Those of you who know me, it's one of my favourite topics, but I think we're absolutely at the end of this story now. You'll be absolutely relieved to know. In fact, it's pretty incredible that we're still talking about it. Many of you will be aware of the long-running saga of the Brazel tribunal litigation. Mrs. Brazel was a peripatetic music teacher, worked both variable hours and term time only, and through her litigation, which went all the way up to the Supreme Court, it essentially identified that the working time regulations had a gap in them, and they did not make adequate provision for people who only worked for parts of a year in that sort of situation. And it meant that all of those individuals who only worked for part year or variable hours were entitled to the full statutory amount of holiday, 5.6 weeks, rather than a prorated amount. So that was the case in the case law. And then the government issued a consultation about it, which came quite unexpectedly, actually. And as a result of that consultation, we have now seen the Employment Rights Regulations 2023 that came into effect on the 1st of January 2024. So they're now in place, but they only take effect in your workplace from the first holiday year from the 1st of April 2024. So for most of you, I think your holiday years will be 1st of September to 31st of August. And if that's the case, these changes apply from the 1st of September onwards, but obviously do check that aligns with your holiday year. And it's worth saying that that's the first time they can take effect. You can delay implementation if that suits you, and depending on how difficult that might be in your workplace. So what do the regulations mean? Well, they amend the working time regulations, which remain the same for everybody else, but they amend them for those categories of workers who are part-year or work irregular hours. So in your school, there's probably 3 different types of worker who fall into those categories. So people who are irregular hours, so that will be all your sort of casual people, variable hour people, the peripatetic music teachers, and all of those whose hours vary from week to week depending on the work available. So they are affected by this, and it means you can now prorate their holiday entitlement again. Those who work part year, there'll probably be 2 types of those. So there'll be those like exam invigilators who work for parts of the year where they might work a lot, but then they have big chunks of the year where they just don't work at all, and generally don't receive pay for those periods. And then you'll have your lots of your support staff on term time only contracts or term time only plus, some sort of arrangement where they work for 34 weeks a year, but they're paid annualized salary to incorporate their working weeks and holiday weeks, and they receive pay every week of the year. So you've got these 3 different categories. So the irregular hours people are, and the people who are like the invigilators, it was absolutely clear that they were covered, and it means that you can now, if you prorate their holiday entitlement, so you can either prorate the 5.6 weeks or you can use the 12.07 figure. And the regulations go quite a long way. They even reverse some of the other case law to say that actually if it works for you as an organisation, you can roll up holiday pay. So essentially you'll still need to be able to demonstrate that they are receiving their holiday, but for every hour work, for example, that you can add on their holiday entitlement and they can receive that in their monthly payroll. So this is a really, really good news story. As I said, the area that was slightly unclear were those individuals who were paid on annualized hour contracts and whether they were part-year workers or not. And the regulations slightly vague in that that's our highlighting, and I think even my red pen, which says that they're only part-year workers if they are only required to work for part of a year and there's at least a week when they're not required to work and for which they are not paid. Now, obviously, they are actually receiving pay, but they're not paid for that week. So it was a bit unclear. And in the government issued some guidance, and the first lot of guidance was issued in January, and it expressly said that people in that who worked under those sorts of annualised hour arrangements, under annualised contract arrangements, were not part-year workers on the basis they receive pay all year round. Well, just that put a cat amongst the pigeons, but actually there's a lot of feedback and we fed back to the government as well, and that clearly wasn't the intention. They just hadn't thought about it properly, and so now they've updated the guidance, and actually it now says, the extracts on the slide, the regulations require that there must be at least a week for which they're not paid. But that means that it would still be possible for a worker to receive pay during that period, as long as there's no expectation of them working, and nor are they receiving payment for that period. So that will be the case for all your term time only or similar arrangements, annualised hour staff. So what does this all mean, and what should you be doing? Well, as I say, you need to work out when your leave year is and when you can first make these changes. Look at the people who are affected. I would suggest you look at those different 3 categories, understand the impact that this is going to have on them. Look at what you're doing at the moment. Is this actually a change or not? If it is a change, what do their contracts say? Do they give you that flexibility? Is it a bit less clear cut? What are you planning to do? I mean, lots and lots of clients sort of unpick these arrangements and have now got different payroll arrangements. So does it work to go back to what you were doing? What works best? Make sure that you've got that plan in place. Think about the timing. It may well be that it's helpful to implement this, from 1st of September, when perhaps pay awards are being made as well. But I'd suggest that you provide notice of the change. So it's worth using this term to let people know. It's my view that actually there's a really clear legal position here that people are only entitled to prorated holiday entitlement, and so this is something that you can implement, but you do need to be mindful that often these will be the people who receive the least pay in your workplace, and so you'll need to think about the impact on them and mitigate how it falls on them. And it's what I just wanted to flag, that if you have got a union recognition agreement, and that's not a topic that we're covering today, but an area where we're seeing huge amounts of development, holidays and pay both are likely to fall within the recognition agreement. And so you will need to consult if you've got staff who fall in this category. It may be that your recognition agreement is only for teachers, but just think it through, and just make sure you're not falling foul of that. And my final comment on this before I hand over to Rebecca is that although we're talking about the statutory holiday, that's the minimum. And so if you do have enhanced contractual holiday, you'll be able to prorate that, but and prorate it down. And the old position following Brazil was that couldn't be less than 5.6 weeks or 12.07, but now it can be less than the 5.6 weeks, but you need to make sure they're getting the prorated amount. So it might not always be 12.07, you might be using a higher percentage. Hope that's all clear. Obviously really happy to take any questions, but I think it is a good news story. I'm going to hand over to Rebecca now, who's going to take us through some of the other changes.
Good morning, everybody. So yes, I'm going to cover the rest of what was on that initial slide. So starting with flexible working, then on to carers leave, protection from redundancy for during maternity leave or adoption leave, and then going on and talk about the changes to paternity leave. So the first here is in relation to flexible working. So this is the Employment Relations Flexible Working Act, already now in force from the 6th of April, and changes the right of staff to make one flexible working request in a 12-month period, and increases that to allow them to make 2 formal flexible working requests in that 12-month period. So schools now under an obligation to respond to that request within 2 months rather than the 3-month period that was there before that, you won't be able to refuse a request unless you've met with the employee in question who's made that request. As you're probably aware, before 6th of April, there was an obligation within any flexible working request for somebody to outline the impact that their change to hours or days, the request that they're making would have on the school, on what would how that would impact colleagues, etc. And there's no longer a requirement to do that. However, we still have to respond with business reasons for refusal of any request, and that's what we would still be bearing in mind when we're looking at how we consider any request that is made. One of the biggest changes here to flexible working is that 26 weeks of continuous service is no longer required, and this is a day one right. And believe it or not, I've already had inquiries where employees are already making that request of a day one position for flexible working, and that's already in force. So people are already moving quickly. So those are the changes to flexible working. And then on the next slide we have carers leave. So carers leave act. This is a new provision where employees are entitled to 1 week of unpaid leave a year for people with caring responsibilities. Again, no qualifying period. It's a day one right. So the moment they start with you, they can request this. Interestingly here, it doesn't have to be taken in a block. So it can be taken in increments of half a day at a time. So anything above half a day or a day, etc., until that full week has been taken for each year, already in effect, and staff have that protection from dismissal if they've taken it. Obviously, doesn't mean they can't be dismissed, but they cannot be dismissed because they have taken carers leave in relation to this right. A very interesting one, which is going to affect decision making here, which is the Protection from Redundancy Act. Now, this is in relation to pregnancy and family leave. This, as we know already, employees who are on maternity leave, they have it's not a protection from redundancy, but it's essentially a priority for redeployment opportunities when there is a restructuring exercise. So if there are no other alternative roles during that period, then there is no requirement to create a role, but where there is a role that somebody on maternity leave can do, there's this positive discrimination duty in order to offer them that role. So this is now extended for pregnant women, new mothers, family leave returners, on the basis that this will be a protection from 18 months from the date that the baby is born. So usually that would normally run, if somebody takes their full maternity leave, then that will run from the 6 months from the return date, usually if somebody returns after a year. Otherwise, it's calculated 18 months from the day that baby is born from in relation to maternity leave. Shared parental leave, shared parental ones, it's also adoption leave, but shared parental leave is interesting because shared parental leave you can take in units of 1 week, but the government didn't want to give people that 18-month protection for taking 1 week. So what they've said is that you have to take at least 6 weeks of parental leave in order to to qualify for the cover here, in order to have that protection from redundancy for that 18-month period. It is going to change things. I was in a client call yesterday where exactly this situation came up, where within the pool of staff, somebody returning from maternity leave, and assumed by the client that they wouldn't have any further protection in relation to the roles, but it's now after the 6th of April, and they do have that protection. Which flows straight into paternity leave, because actually, interestingly, at the moment, there's no protection for somebody on paternity leave when they return from that paternity leave. And often paternity leave can be taken in, and much more commonly nowadays, to be taken in longer chunks than 2 weeks, and that sort of annual leave can be tagged on, or unpaid leave tagged on, but there is no protection there. And I wonder if that's something that's coming down the road. But paternity leave amendment regulations are now in force, and what this says is that the 2 weeks of paternity leave doesn't need to be taken in a 2-week block anymore. So it changes the way that leave is exercised, and can now be taken in 2 1-week non-consecutive blocks at any point in the first year after birth or adoption, and just 4 weeks notice required to take that leave. And again, if you've planned for it at some point during the year, only 4 weeks, so 28 days notice required to amend or change if your family requirements have changed, or something has changed, meaning that you want to change the date of that leave that you want to take, you can do that. And again, it actually came into force I think in March, 8th of March, but it's only for babies born on or after the 6th of April. So, or a placement on or after the 6th of April. So for all intents and purposes, 6th of April is our key date here. So that is over to Joanne for looking further ahead, and I'll come back in a little bit. Thank you.
Thanks, Rebecca. Morning, everyone. So I'm going to look a little bit further ahead at some changes on the horizon this summer and beyond. So you can see on the slide there that we've set out what those changes are, and I'll go into a little bit more detail on some of the more relevant ones. But if we start with changes coming in on the 1st of July to TUPE. So in relation to TUPE, sometimes it can be a little bit labour intensive in terms of putting in place elections and appointment processes to elect employee reps where you don't already have trade union recognition or a workforce council in place. And so the changes coming in for transfers after the 1st of April mean that it's actually a little bit more simpler for smaller transfers. So where 10 or fewer employees are involved and affected by the transfer. So if you're looking maybe at a catering outsourcing or a cleaning contract, you'll be able to consult directly with them rather than going through that election process, providing that there aren't any existing representatives in place. And also, if you're a very small school and you've only got 50 staff, you'll be able to consult directly on transfers. So if you're merging, for example. So that's a little bit of good news in terms of making TUPE a little bit more user friendly. And then if we move on to changes around fire and rehire. So what is fire and rehire? It's a sometimes controversial practice. It relates to changing terms and conditions by terminating existing contracts and then are making an offer to re-engage staff on new contracts with new terms that generally are seen as less favourable by the employees. So it's generally used where agreement can't be reached, and the practice came under the spotlight probably during the pandemic with the P&O Ferries case, and also other cases where it was seen to be used as a bit of a strong arming tactic to push through changes without really thinking about the impact on staff or really consulting with them in a meaningful way or at all. And so the government asked ACAS to look into it, and ACAS put out some guidance to assist employers. And the government has now moved a step further in terms of putting a draft statutory code in place to try and provide a deterrent for employers from acting in potentially unscrupulous ways when it comes to changing terms and conditions. And so the code, which went out for consultation and has now come back, seeks to put in place a more transparent way of giving information at an early stage to staff who might be affected, where you're looking to change terms and conditions. So if you're looking to make changes to pensions, for example, if you're coming out of the TPS or looking at other pension options, you would be looking to consult at an early stage with staff, providing lots of information to them so that they can fully understand the proposals, what it means, why you need to do it, and so that they can make informed decisions. The code has 9 sections, I think, to it. It follows what we've been advising and practitioners have been advising as best practice, but with some extra added bits. So now within the code, there's an obligation or a recommendation to involve ACAS at an early stage to seek their guidance and support and see whether they can assist the process. It's not entirely clear as yet exactly what ACAS's involvement will be or what resources will be given to ACAS to help employers. We've put some calls into ACAS to try and find a bit more information out, and I think they're still working out what support that they would be able to provide to employers. But there is that recommendation there. There's also a recommendation in the code to employers to re-examine their plans if consent to the changes can't be reached, and to look at what feedback they've had through the process and to really explore, could they make some changes or alterations to the plans that they're proposing to try and get agreement or limit the impact that termination and re-engagement might have. And the ethos of the code is very much that termination and re-engagement should be a last resort, and that it shouldn't be raised unnecessarily early in negotiations so that it appears like a threat, and that it should be presented or framed in a way that is not an ultimatum, but a sharing of information of the direction of travel that the process potentially could go. Because there is this obligation or recommendation to look at re-examining your plans, it's important for schools to be thinking about how they document how they're complying with the code once it comes into force, and ensuring that the record keeping demonstrates that. So the code itself doesn't create legal obligations, but it does refer to obligations that already exist, and it uses the language of must and should to differentiate between what you must do because there's already an existing legal obligation, what you should do in terms of recommended best practice. And if you deviate from any of those recommendations and there is not a reasonable reason for doing that, then there is the prospect of potentially having an uplift to any compensatory award against you of up to 25%. So if you're looking to change terms and conditions of a lot of staff, it could be very costly if you don't have a good reason to deviate from the code, because it could be seen that dismissals are unfair, or if potentially if someone says that the changes to their terms and conditions are discriminatory, there could be an uplift in that award as well. So whilst it doesn't create a legal obligation, or it doesn't create a claim in itself, it's important to be mindful of the code in changing terms and conditions, because that uplift could have significant consequences. And the code's due to come into effect in the summer. So the next point I wanted to talk about is the right to request a predictable work pattern. So this is something that came out of the Taylor Review, which some of you remember, explored inequalities in the workforces. The review took place some time ago now, but really it looked at the use of things like 0-hours contracts and how it created for certain staff on those contracts instability, financial uncertainty, and it felt that there was sort of a mismatch of balance of power in those relationships, and some of the recommendations have sought to address those. So the right to request a predictable working pattern is or follows quite a similar approach to flexible working requests. So staff who are able to bring or make that request would present it. You would have an obligation to meet with them and discuss it, and you'd have a reasonable time frame in which to respond to it. The staff who can bring those claims are those who have irregular hours or short-term contracts, or agency workers are entitled to make requests for a more stable work pattern. And the grounds for declining those requests are again very similar to those that are currently in place for flexible working. At the moment, we're waiting for secondary legislation to make it clear exactly how the Act will come into place, but it's thought that it's likely to be a 26-week minimum service requirement to be able to make the request, and that 2 applications would be able to be made in any 12-month period. There is some draft ACAS guidance in relation to the process for making the request, and that sets out timeframes and looking at how the process is dealt with for agency workers on one hand and then your own workers on the other. So if we move on to the next slide, please. And we look at some family-related rights that are due to come in later this year, and in particular neonatal care. So this is expected to come into force in 2025, and it would apply to the parents of a baby that requires neonatal care, and it will provide up to 12 weeks statutory leave for those parents. Currently, there's no right to that kind of leave, and for parents and partners of mothers in particular can quickly use up paternity leave and other types of leave, and their baby might still be in receiving high dependency care during that time. And so this right is to help parents in that situation, and it will have similar pay regime as statutory maternity pay or statutory paternity pay. If we move on to the next slide, please. And then employment tribunal fees. It's probably about 5 or 6 years ago now that employment tribunal fees came in for the first time. And there was quite a lot of criticism that they created a barrier to individuals from being able to seek support from the tribunals and access justice. The fees at that time weren't particularly high, and there was a remission scheme in place for those who weren't able to fund the fees. However, they were scrapped after, I think, a year or two. And now there is some consultation on whether fees should be reintroduced, but at a lower level, perhaps to deter some of the potentially sort of nuisance claims or lower level claims. And that consultation is now closed, and we're waiting to see what the outcome of that will be. So that's more of a watching brief, but something that is on the horizon. And now if I hand back to Rebecca, who's going to talk about prevention of harassment.
Thanks, Jo. So yes, and actually there's a question in the Q&A about prevention of sexual harassment, and it's absolutely hit the nail, and it's talking about how we can proactively prevent it, and what we can do with changes to policies. I will cover that as part of this section of the session, to let you know what we think that you can do. But that's exactly what has happened. There's now this proactive duty that essentially at the moment there is this reasonable steps defence. We're talking here about sexual harassment. So in terms of sexual harassment, we're talking about where somebody engages in unwanted conduct of a sexual nature, which has the which violates a person's dignity or creates an intimidating, hostile, degrading, humiliating, or offensive environment. And at the moment, there is a defence to that, where an employer has taken all reasonable steps. So as it stands, the Equality Act essentially says that employers are liable for all acts of harassment carried out by employees in the course of their employment, even if the employer is unaware of the employee's conduct prior to the complaint being made. Now, that current law relies on employers obviously bringing that to our attention and letting us know, so that then we can say, well, actually, we have taken all reasonable steps to prevent that harassment. So now on the next slide, there is information about the new act that is being introduced and coming into force later this year, so on the 26th of October, which is the Worker Protection Amendment of Equality Act of 2023. And essentially puts this positive duty on employers to show that they have done taken every step that they can do to prevent sexual harassment of its staff. And this proactive step, failure to carry out a proactive step to show that the reasonable just steps have been taken, can increase a compensation by up to 25%. So you're probably aware of the same uplift for failure to follow grievance, for example, grievance and disciplinary procedures under the ACAS code. Exactly the same situation here, where that 25% increase can be applied. On the next slide, we're going to look at essentially what's really changes. Well, obviously there is the somebody can bring a sexual harassment claim, but then there's the failure to carry out these reasonable steps. So it's a mandatory duty, a separate claim. So it's not just a defence that we have to be carrying out steps to ensure that sexual harassment does not occur in the workplace. It has been watered down, so it's not all the reasonable steps, so everything that could have possibly be done is done, but it's reasonable steps. So what can you as reasonable employer reasonably do to ensure that staff are not harassed in the workplace? Again, it's not a standalone claim, so enforcement will be through the Equality and Human Rights Commission, and statutory code is expected. Harassment through third parties, this was going to be covered actually by this piece of legislation, and it was big news when it was proposed. Essentially, the government got spooked, and it was thought it would interfere too much with freedom of speech and policing conversations, and too difficult to enforce. And so, therefore, because of this lack of control, it was dropped. But apart from third parties, then it includes all your staff. And what can we be doing? What are the practical tips we can give you to look at it? Well, really, my view is it starts with leadership. It starts top down. Ensure the leadership of the organization sets a zero tolerance in relation to sexual harassment. That approach, from a practical perspective, it's with formal statements, it's with intranet, it's with comms. If you have a situation where somebody makes a complaint, but they say, look, it's okay, I don't mind, I just want them to apologize. Actually, maybe an apology is not the right answer here, and you might have to deal with that in a much more formal stance, because you're showing, even though the employee might just want an apology, we are saying we have a zero tolerance. And if our policies say we have a zero tolerance, we have a zero tolerance. And that goes on to sort of creating this culture of a supportive culture where sexual harassment is not tolerated in any form whatsoever, and that you have support and mediation and counselling, for example. And sorry to sound like a very boring lawyer, but your policies, don't just have your policies. What are you doing with those policies? Are we making them available? And not just so harassment policies, we've got grievance policies, which are relevant here, bullying, harassment, whistleblowing policies. Make sure they're all up to date and that we're doing something. Are we training staff? Are we letting them know? What does zero tolerance actually mean? What does banter mean? What is acceptable and what is not acceptable? And I think that by creating that sort of top-down zero tolerance approach, you're saying to staff, this is what is important to us, and these are the steps that we're taking to ensure that you are safe. It's also very much our door is always open, because the reasonable steps defence relies on staff telling us what is going on in order for us to be able to then show that we have put in all reasonable steps. But now, having that open door policy, so we're aware of everything right from the get-go, that people can talk if somebody's uncomfortable, to stop certain behaviours before they even start, is absolutely the place we want to be. So we're now going to provide an update on some of the recent case law. I'll start with 3 of the most recent cases, and then Alice will take over. So the first one is the Sean Pong Tyres Limited and Moore case. This is the claimant, Mr. Moore. He brought claims actually not just of harassment, discrimination and unfair dismissal. He resigned his position, and essentially all related to the conduct of another employee, Mr. Owusu. And he resigns his position because of the conduct. And then there was a TUPE transfer. Mr. Owusu transferred to a different employer. And what the tyre company wanted to, or they did try and argue, was that actually this wasn't their problem, because the perpetrator essentially was with a different organisation, and that organisation were to take on this the claim, or to defend this this claim. And in relation to the unfair dismissal claim, the EAT noted that actually the claimant resigned well in advance of the TUPE transfer, so it was unconnected to that transfer, and he was employed at all times by the respondent, and so liability essentially lay with the respondent. And it's common sense, really makes sense that actually it's not going to transfer. And what's really important here, perhaps critical, is that no claim was brought against the Mr. Owusu personally either, so nothing transferred over with in terms of liability, because in relation to the Equality Act claims, the tribunal and the EAT had the same conclusion, that essentially it is the respondent's liability to the claimant did not transfer over, and so therefore they were ultimately responsible in terms of all those claims that he had brought. TUPE didn't make a difference. So we have to look at that when we think everything transfers over. Not everything always does transfer over. The next case is that of Sullivan and Isle of Wight Council. Interesting case where the claimant, she applied for 2 jobs at the council, an external candidate, so wasn't already employed there, and she then so she didn't get the jobs, either of them, and she then made allegations alleging financial irregularities around processes regarding the people that interviewed her, and she made a formal complaint. And what the council did is they dealt with that complaint through their formal processes, and they did a full investigation. It actually had quite a significant impact on their staff and their well-being, and the outcome of that process was that there was no wrongdoing, and that she that there was no issue with these interviewers, and they didn't give her the right to appeal that process, because they were looking after the well-being of their staff, and they decided, because she's an external candidate, we're not going to give her the right. And she then brought a whistleblowing claim, and she said that her detriment was the failure to allow her the right to appeal that complaint. And she says that she made a protected disclosure regarding the financial irregularities, and the refusal to hear that then appeal was her detriment. And essentially, the tribunal and the EAT both found that a job applicant is not in the same position as an internal applicant. No surprise there. I don't think this is great shakes. And her status as a job applicant was not the reason for the less favourable treatment, or her essentially what she was saying was her detriment, and therefore she's not entitled to whistleblower protection. So what this differentiates between are discrimination claims by a job applicant, where job applicants are protected by the discrimination legislation, and then whistleblowing protection, which they are not protected by bringing a protected disclosure. And then the final case, which I'm going to cover today, is the Glasson and Insolvency Service case. Really interesting case, actually, helpful for employers. This was where Mr. Glasson applied for an internal promotion. So he was already an employee, and the employer was aware that he had a disability under the Equality Act, and he had a stammer. And so for this process, they gave him a little bit more time to answer questions, so that he had the reasonable adjustments that he had asked for in order to be placed in the same position as other candidates. And he missed out on that promotion, so he didn't get it, and he only missed out by 1 point. And he said that actually the organisation failed to make reasonable adjustments because he went into something that he called restrictive mode, which is something that somebody with a stammer might go into, which stops him being able to answer the questions properly, and therefore they didn't make reasonable adjustments to counteract that. And here, what the EAT have said is that although the employer knew that the job applicant was disabled, they found that they didn't have constructive knowledge of the disadvantage in question, so this restrictive mode, and so the reasonable adjustment claim failed. And to me, that makes perfect sense, that actually they did everything they could do when you have knowledge of something to be able to make those adjustments for a job applicant or employee. But where you don't have that constructive knowledge, that they went into quite a lot of detail actually as to him not providing the information and him not providing what reasonable adjustments he might require in that job interview. And so actually the employer in this situation had done nothing wrong, which is reassuring. And over to Alice.
Thanks ever so much, Rebecca. Yes, I've got 3 more cases which we've seen over recent months. And the first one, Mrs. Brooks and Leisure Employment Services Limited. The backdrop to this is COVID, which is quite interesting. It's nothing to do with COVID really, but it just sort of flashbacks when they're talking about home working groups and WhatsApp and things, but also how long it's taking for cases to get through the tribunal system. So Mrs. Brooks essentially raised concerns about how she was being paid during the pandemic. And then rather than address this, Leisure Employment Services Limited simply took her off the home working team and took her off the group WhatsApp. She brought a grievance to complain about this. It went through the grievance process. It took about 3 months. We all know how long these things can take. The grievance wasn't upheld, and following this, she resigned. And then she brought a constructive dismissal claim. So constructive dismissal, essentially, she felt that she'd been forced out of the organisation by the way in which she'd been treated by the employer, that they'd breached the implied term of trust and confidence. And the case looked at this and the principle of whether the fact that she'd stayed in employment and brought a grievance and complained using the internal process and remained in employment and received pay for at least 3 months meant that essentially she'd lost the right to bring a constructive dismissal claim because she'd affirmed her contract and accepted their behaviour. Well, at the tribunal level, that was what they found. They said, if somebody acts in fundamental breach of your contract, you need to leave straight away. And if you stay, you're affirming the contract. She appealed and it went to the EAT, and the EAT agreed with her and disagreed with the original tribunal. And they said, well, this is not a case where somebody just carried on working and clearly was in agreement and affirming that they didn't mind what was happening. The fact she'd raised a grievance was demonstrably saying, I'm unhappy about this, and actually wanting them to sort it out. And so it was entirely reasonable for her to raise that through internal channels and through the grievance process. And the fact then she didn't get the outcome that she wanted, she could resign and claim constructive dismissal at that point, and her claim wasn't undermined. So I think it's a useful case in terms of just giving us a bit of clarity about that. But from an employer's perspective, actually, it's really good to encourage employees to, if they've got concerns, to use the grievance process. And actually, sometimes things do go wrong, and you can use the grievance process to really properly address things and look at rectifying them and resolving them, and you're expected to do that. And actually, it could have been quite a different outcome if they hadn't just simply dismissed her grievance, but looked at resolving it. And then it may be that she didn't have such a strong constructive dismissal case. So yeah, hopefully quite an interesting one. The second one we wanted to mention is Omar and Epping Forest District Citizens Advice. I think it's always interesting when a case involves a firm of lawyers or the Citizens Advice Bureau, who should probably know better. And this involved an individual who resigned in the heat of the moment. And you're probably all aware that generally the principle in law is once somebody resigns properly, then that's binding and they can't retract it. So you as an employer aren't obliged to agree that they can withdraw their resignation. But there are some limited exceptions to that, and this case of Omar looked at that. So essentially there was a meeting between Omar and the line manager, Mr. Omar and his line manager, which was pretty heated, and they fell out with each other, and he clearly, unequivocally said he could not stay and he wanted to resign, walked out of the meeting. He didn't then put his resignation in writing. He actually had some conversations with the CEO of the Citizens Advice Bureau, and in that conversation it was acknowledged that he really wanted to stay and perhaps there could be an alternative for him. But then they spoke to the line manager and said, no, we're going to hold your resignation. You can't work. And he brought a claim and essentially argued that they couldn't say that he had resigned, that essentially he'd been dismissed by them by reason of their conduct. And the EAT agreed with him and said, actually, this isn't an opportunity for employers to seize on, and when there's a difficult problem or when there's a difficult employee, and we all know how convenient it is when someone says, oh, I'm going to leave then, or oh, well, I'll tender my resignation. And when you think, goodness, wouldn't that be good and solve this problem? Sadly, you can't just say, great, that's it, march them out of the door. You can't change your mind. This, the test that the EAT said the tribunal needed to look at was really whether the objectively a reasonable employer thought that employee seriously meant that resignation and really intended to leave their employment. And actually that's the question that the tribunal should have been asking themselves. And so the EAT remitted this back to the tribunal, to a different tribunal, to test the circumstances based on those tests. And so I would say to you, generally, if someone resigns verbally in a meeting or where they're clearly upset or haven't thought it through, however tempting it is, you should tell them to reflect that you can't accept their resignation then and there, that they need to go away. If they want to genuinely resign once they've had a moment to think about it, that they should put it in writing. Once they do that, and if they do put it in writing, you're on solid ground. You're really on solid ground to accept that resignation. And then even if they change their mind later on, you're not obliged to allow them to rescind that. So gives a bit of helpful guidance about those situations, which do arise in practice from time to time. And my final case that we wanted to mention, you may have seen in the press, and it related to a lady, Mrs. Umba, and Michael Garrett Associates. She was cast in the role of Feely in the Colour Purple, and some of you who know the book or the play and the film will know that that's a role which involves a lesbian relationship. So Mrs. Amuba had strong Christian beliefs, and what was discovered was that historically she'd made a number of social media posts and things in which she'd essentially said that she knew that homosexuality was lawful, but she didn't think it was right. and those attracted a lot of negative attention and were reposted. And the theatre was very concerned about the negativity and the adverse reaction of the social media storm around this. They were worried that it would impact on the artistic merit of the play if people sort of came knowing that she was this high profile individual now, and that they wouldn't believe her in the character in the same way. They were worried about there being protests outside the theatre, and they were generally worried about the negative press attention and media attention. And so they brought her contract to an end. They actually honoured to pay her contract in full. She brought a claim to argue that she'd been discriminated against based on her Christian views. And so that was considered, but it was interesting that she was unsuccessful. And the tribunal essentially drew a line and said this was not because of her Christian views. It wasn't actually even because of her manifestation of those Christian views. Actually, this was because of the consequences of the manifestation of those views and beliefs, and they accepted that the reason the theatre company made its decision was because of those consequences, and not because of the views themselves, or even her expression of her views. We're seeing a lot of cases along these sorts of lines, and Joe's going to talk about them in a bit more detail in a moment. But this one is really helpful in emphasising the importance of having a really clear audit trail when you're making a decision in what we know might be contentious or sensitive circumstances. Taking some time to properly articulate the reasons for those decisions, having the evidence that's supporting those decisions, and making sure that's consistent in any process that you're following in any outcome letter can really help when someone argues that this is related to a view or belief that's protected that they may have. So I'm going to hand over to Joe, who's going to talk to you a little bit more about cases on the horizon.
Thanks, Alice. So if we look at the first case, I say on the horizon, but we actually had a declaration in from the Supreme Court yesterday, so very timely when talking about the Mercer case. So for those of you who don't know what Mercer was about, it's in relation to whether someone who plans or takes part in industrial action, so strike action, is protected from suffering a detriment as a consequence of that. Mrs. Mercer was employed by Alternative Future Group. She was a workplace representative, and as part of that role, she was involved in planning and organising a series of strikes back in 2019. She was subsequently suspended and disciplined, and she received a first written warning for abandoning her shift. And she brought claims that action was a detriment for her undertaking trade union activities. And she brought a claim saying that action was contrary to Section 146 of TOLRCA, because she'd been participating in activities on behalf of her trade union. And if we look a little bit more closely at what protections are afforded currently under TOLRCA, so workers are entitled under Section 146 not to be subject to a detriment short of dismissal for being a member of a trade union or taking part in trade union activities. There's a separate section that protects workers from dismissal for the same reasons. And then there's a further section that deals with dismissal for those who take part in industrial action. So it separates out what is trade union activity from industrial action. So it sort of creates that separation and shows that there's some distinction between strike action and other union activities. And in this case, that distinction and that there wasn't a similar detriment protection for taking part in industrial action led to a decision at Court of Appeal level that there wasn't protection for those who participate in strikes from being subject to a detriment for having done so. That was appealed to the Supreme Court, and essentially the basis of the appeal was whether Article 11 rights were breached. So the right of freedom of association and assembly, in not having our domestic laws protect detriment from acting or taking part in a strike, and whether by not offering that protection, it was not upholding those human rights around freedom of association and assembly. And so the declaration that was made by the Supreme Court and that was published yesterday went beyond what the Court of Appeal had said, and it did find that Section 146 as currently drafted was incompatible with Article 11, and that there should be essentially similar protections for suffering a detriment for taking part in industrial action as there are in terms of taking part in other trade union activities. But the way in which the legislation is currently drafted means that you can't interpret it in that way, because it's very clear that it looks at a different set of rules, as it were, for industrial action as opposed to normal trade union activities. And so what the Supreme Court has said is that it's now a matter for Parliament to legislate and to look at whether they amend TOLRCA to bring in protection against detriment for having taken part in industrial action. So it sort of brings to almost the end the trajectory of the Mercer case, and highlights the need, if you're experiencing any industrial action, to think about carefully about any action that could be seen as detrimental to those who've participated. So, for example, if someone who's participated in a strike isn't considered for a promotion or training opportunities, or their pay award differs from others, and they can trace that back to having participated in a strike, then there's likely to be more protection for that going forwards. So if we move on to the next slide, please. And it's sort of circling back to what Alice was talking about in the Amoeba case. Balancing protected beliefs has been something of a hot topic for a significant period of time now. It must be 4 or 5 years, in which the almost the extension of protection of what some might call minority rights has led to a number of claims and a bit more of a settled approach now in terms of what would qualify for protection under the Equality Act. And it's a tricky area for schools to navigate, because you often have conflicting rights or protected characteristics, and that can be difficult to manage in the workplace with 2 employees who have very differing views on what can be quite an emotive topic, and difficult to navigate in terms of how that affects the reputation of the school. Lots of the cases that I'm just going to run through quickly talk about social media activity and what those with or holding protected beliefs have put out online, and how that then is perceived by their employer as being negative to the employer's reputation. And for schools, reputation is everything, and it's really important to maintain that brand and maintain good relations within the school community with parents. And if teachers or other members of staff are putting things out into social media that create something of a media storm, or create discontent or disquiet from parents, it can obviously be very concerning. But the flip side of that is that taking action could result in someone who has a protected belief bringing a claim against the school. And so it's understanding where that protection exists, and understanding when that protection might not protect actions or manifestations of those beliefs. And so if we think about the Forstetter case, Forstetter was decided a couple of years ago now, and in that case it involved Miss Forstetter putting comments online which expressed her beliefs of gender critical beliefs, that biological sex is binary and can't be changed. Those comments attracted some concerns, and those concerns were related to her employer. Her employer sought to bring her fellowship to an end, and as a consequence of that, she brought claims of discrimination based on her protected beliefs. And Forstetter established that gender critical beliefs are protected by the Equality Act, and that a decision to essentially bring her employment to an end because of how she expressed those beliefs was a discriminatory action on behalf of her or by her employer. And it explored concepts around the way in which she manifested that belief. So the comments that she made were an expression. They had no I suppose no victim, if you think about it. It was a comment to the world at large about her views, and though some of her colleagues found those views distressing, upsetting, didn't agree with them, just because that they found or disagreed with her didn't mean that she had behaved in a way that infringed their rights. And so her rights took precedence, in the sense that she had the right to express them. She did it in a way that wasn't considered to be objectionable, and therefore terminating her employment and removing her details from their website was an act of discrimination based on those views. If we look at the Higgs and Farmer school case, this involved a Christian member of staff who had posted online comments about an initiative in the school. Those comments were seen to be homophobic and transphobic, and generated some concerns from parents and the wider school community. And the school ultimately dismissed Mrs. Higgs, and she brought claims in the Employment Tribunal. And at first instance, her claims failed, and it was felt that the decision to dismiss was essentially because of a reputational damage. But on appeal, the EAT found that the tribunal hadn't really looked into whether the decision to dismiss was based around the manifestation of her belief, and that they should have considered that in more detail, and how closely connected those posts were to her Christian views, and whether, as a consequence of that close nexus of the views and the manifestation, that the action of terminating her employment because of them was discriminatory. And so that case has been remitted back to the tribunal to consider those points around, were the ways in which she manifested her Christian beliefs objectionable, and could, based on that objectionable manifestation, the employer lawfully terminate her employment, and was termination a proportionate way of dealing with the situation, or was the manifestation actually something that was acceptable? So it shows how nuanced the situation has become, and looking at how closely connected the actions of the individual are to the actions that you take as an employer in response to them, and understanding and assessing what is objectionable in terms of that manifestation. So if it clearly impacts the rights of others, so if Mrs. Higgs had made comments directly to a gay member of staff or a gay student, that would have potentially been an act of harassment against them, and that would clearly be objectionable. But if comments are just made open to the world at large without a victim or rights being infringed, is that objectionable, or is it a permissible expression of their beliefs? Case of Randall and Trent College concerned a school chaplain who had made certain comments in a sermon that again comments that around a process or an initiative to end bullying or harassment of those with protected characteristics, and he made comments that essentially could be considered to be homophobic or transphobic, and concerns were raised because of the way in which he objected to that initiative coming into force, and that he'd raised it during the course of a sermon and it wasn't considered to be an appropriate forum to have done that. And in that circumstance, the school took action against him, and it was found on that basis that the way in which he had manifested his beliefs in that sermon was objectionable because he had been advised not to do it. It was considered the wrong forum to do it. He'd been given previous cautions against doing that, and in those circumstances he chose to air his personal views and to try and influence others with his personal views in circumstances where he knew that that wasn't appropriate. Miller and University of Bristol, in this case, a university professor had made anti-Zionist comments in lectures and in various other forums within the university, and the tribunal held that those beliefs were protected. And he was successful in bringing a direct discrimination claim that his dismissal was directly discriminatory for having held those beliefs. And Alice has talked about Amuba, again, another case that looks at what is the reason for the action that the employer took. So in that case, it was about the media storm that came up out of the comments that Amuba made some time before taking on the role, and how that would impact her portrayal of the role and the believability of her in that role, and also the commercial impact of having protests and having the impact it could have on ticket sales, and that it was that impact that was the reason for her termination and not the views themselves. So if we go on to the next slide, look a bit at some practical things to think about. So it's important within your policies and in your approach to how you deal with conflicting protected beliefs to consider that the threshold for a belief to be protected is quite low, and to explore what might be the motivator for comments made or actions of members of staff, and whether a protected belief could be behind them or it could be a manifestation of a belief, just to make sure that you're not inadvertently walking into a situation where you could find yourself on the end of a discrimination claim. That beliefs that might be considered minority or upset members of staff don't necessarily are not unlawful, and there needs to be an element of tolerance within workplace and making sure that staff understand that differing views are okay, and it's about expressing them in a way that is tolerant of others and understanding of others' views. And then considering if there are circumstances where someone has raised or taken an action in the manifestation of their belief, whether that was objectionable, and looking at what the impact was. Was a student affected? Was a colleague affected directly by it? Were their rights infringed? Did it break a policy that you have in place? And thinking about, ultimately, is the action taken because of the need to address reputational damage? Is that the reason for taking disciplinary action or for terminating the employment of a member of staff? Or is it because of the views themselves? And how can you document that, and making sure that you've got good records of your decision making is important. If we move on to the final slide. So some things that you can think about putting in place are ensuring that that your training is there around protected beliefs, and putting forward that ethos of tolerance and understanding, and making sure that your policies for certain areas are reflective of minority beliefs as well. For example, if you had a policy on using pronouns, preferred pronouns, for example, considering how that might impact those who have gender critical beliefs, and thinking about what can be done if they would struggle to follow that policy, so that the policy is balanced and reflective of the differing views that you might have within your school community, and is not seen to be not listening or hearing the other views within that community. And thinking about updating your bullying and harassment policy to make sure that it's reflective of various different views within the school community. And also social media policy is important because lots of this emanates from things that people put online. So asking staff to state that they are expressing their own views. If they're putting comments online, making sure that your social media policy doesn't stop the expression of a protected belief, but that there is guidance around how to think about moderation in how things are posted and the language used, and how that might reflect on the school, and how that might be perceived by parents and by students, and all of the other usual social media policy advice, in terms of distance from the school's reputation, or distance from being identified as an employee of the school, and being clear that posts and comments made are in a personal capacity and not on the school's behalf. I think that brings us to the end of sort of cases on the horizon. We have created some e-learning that addresses some of the points that Alice, I, and Rebecca have raised around prevention of harassment and looking at managing conflicts around protected beliefs. We've got a series of EDI courses that deal with anti-harassment, help with learning about unconscious bias and preventing unconscious bias, and also for managers who would be leaders within your school on tackling equality, diversity and inclusion issues. So if you are interested in hearing any more about that training and how it can help in terms of that proactive duty around creating reasonable steps, then please do pop a response in the poll here.
Thanks very much, Jo, and thanks everybody. We've got a good 10 minutes or so for questions, and there are a few questions in the Q&A box which we'll rattle through. I think while we're doing those questions, Tamar is going to kindly put up a feedback poll as well. So please do share your feedback, and as always, if there's any topics you'd like us to cover in future, do let us know as well. There is one question in the chat that I will cover first, which was around flexible working, and Rebecca, maybe you pick that up, but Jo, do chip in, and it's around the 2 months time limit, which is quite tight now, and whether it's possible to extend that and how you'd go about doing that.
Yes, so it's the same as before with the 3-month time limit, that it's fairly strict unless you have consent and you agree with the employee to extend it. So once you have that agreement, then absolutely you can extend it beyond the 2 months as long as there is agreement with the employee.
Yeah, thanks, Rebecca. I would say that we do know that it's tight to deal with these things. Often if someone puts in a request just before a school holiday, for example, so it's helpful to map out the process and look at the dates. And if you realise early on that you're going to need to extend it, agree it sooner rather than later, because an employee is more likely to agree it right up front than if you've said, for example, you're not agreeing to their request and you have to extend the time for an appeal. They're less likely to agree. So just think, so I'd get on with it quickly if you do need to extend it. Then let's go to the Q&A. There are lots of holiday pay questions, which I will do my very best to tackle, and then I'll but Jo and Rebecca, again, if there's anything you want to add, please do, and if there are non-holiday pay questions, I'll forward them on. So the first question is around my final comment to ask about how the 12.07% changes if you've got a higher contractual organisational holiday pay. So just to run you through that really quickly, the 12.07% is created by essentially treating it as a sum. So 5.6 weeks is the statutory amount divided by a full working year, which is 46.4 weeks. So that's 52 less the 5.6 weeks. And if you do that, that essentially captures, that results in a percentage of 12.07%. So 5.6 weeks as a percentage is 12.07. So you need to do the same sum if you've got a higher amount. So just by way of example, so let's say you've got a 7-week holiday entitlement. That's an easy sum for me. So 7 would be the top of that division. So 7 over, and then the number at the bottom would be 45 because it's 52 as a whole year, less your 7 weeks. So 45 weeks is the most that somebody who works all year round would work. So 7 over 45, and having just done the sum, that results in a percentage of 15.56%. So you can use the 15.56% as the percentage for every hour or day that somebody works. I hope that's clear. Sorry, hard to do that over a webinar, but if you do want me to look at any particular sums or anything, please do drop me an email. I'm happy to help with that. The next question is somebody saying, despite Basel, they didn't make any changes to how holiday was calculated for casual employees. You're probably lucky. You probably don't need to do anything else. Keep your head down and power on through. Technically, individuals could bring a claim within 3 months, really, of the last holiday year for arrears, 2 years arrears of the difference, and technically they'd succeed. But if you haven't had any grumbles and no one's raised it yet, we've had a surprisingly few challenges from unions and things in the independent sector. So I think you're probably okay to just carry on as you are. Jo, Rebecca, you wouldn't say anything different to that? Yeah. Oh, third holiday, yeah. What the third one is around, if you are going to do a rolled up holiday pay sum, so that for irregular hours people are working and then receiving holiday pay, what's the best way of doing that? My view, though the law these days has changed, because you have got the statutory right now to sort of roll up. You don't have to rely on it being absolutely clear, but still best practice would be that you can absolutely demonstrate that they have got a pay rate for their working time plus their holiday time. So ideally that would be on the pay slip, but if it isn't on the pay slip, it should exist, you know, somewhere so that they understand that, and in the contractual documents, really. And what I wouldn't recommend is just saying you're paid this an hour, which includes holiday, because I think then it's very hard to show that that is really the case. Oh, another holiday one. Oh yeah, so this relates to that question that permanent full-time employees have a greater holiday entitlement than 5.6 weeks, but some employees like VMTs and casual contractors like invigilators only statutory. Is that okay? The answer is yes, it is okay. You just need to be a bit careful that people are protected under the part-time workers regulations. So if they are doing a comparable job and they are essentially, it's just the fact that they're on a 0-hour contract or a variable hour contract that's different, then they're comparable and they should have the prorated amount of the full amount. But if they're doing something different and they're on a different type of contract, so the VMT is a good example of that, or invigilators, then you might well be able to use just the statutory amount, because you're going to say they're not comparable to your other types of employees. Phew, there's a non-holiday pay question. Rebecca, I'm going to throw it to you. What happens, it's about the redundancy situation, and what happens if an individual has a miscarriage? And the questioner has said, I think after 24 weeks, it's considered to be a stillbirth, and would they still have that level of protection?
So that's absolutely right. After 24 weeks, they have the same protection as maternity leave, essentially. If it's under 24 weeks, they have a protection from 2 weeks from the miscarriage. So it's not a particularly long period of time, but they are reflected in the legislation, and it's 2 weeks after the date of the miscarriage.
Thanks, Rebecca. And the next one's about sexual harassment. You covered this a little bit. I might ask Jo, and then you can chip in if you've got any additional thoughts. So the question is around, in relation to the prevention of sexual harassment, what should schools be doing proactively in training staff or changing policy? So Rebecca have you and Jo's touched on it, but Jo, I don't know if you want to talk in any more detail, or Rebecca?
Perhaps to do, here's a shameless plug for our online training, but it's showing that you are asking staff to do online training, and that you're doing that up front before anything happens is a great way to show that you are proactively assessing the situation and any risks involved.
Absolutely, and making sure that training's effective, that it's working, that you're monitoring its progress, looking at things like staff surveys as well, and seeing if there are issues within the workforce. Sometimes you don't want to look too deeply under the bonnet, but giving staff an opportunity to voice their concerns and tell you how effective they feel that the training they've received is helpful feedback and good documentation, and making sure that each manager or each leader or each department head has had a greater degree of training to understand their role in sort of leading from the top down, and making sure that people know how to report harassment as well, being proactive with that, having sometimes you have an email address to be able to report things through, or having access to HR to be able to do that is a good way in showing how proactive you are in trying to prevent harassment in the workplace, sexual harassment or otherwise.
Thanks, Jo. That's really helpful. There's another question about harassment that I might cover off before going back to holiday pay. Somebody has commented that harassment is having an express zero tolerance policy, which perhaps then removes the risk of potential perpetrators having discretion as to what behaviour is acceptable or not. And I think you mentioned this, that really it is important that it isn't down to individuals to decide what is appropriate and what they consider to be just fun or just having a laugh, that actually the legal test for harassment is a subjective one based on the person who's received that harassment, although it's got to be objectively reasonable in all the circumstances for them to feel that way. So absolutely, I think having your policies which set out the behaviours that you as an organisation consider to be unacceptable, and to have training that reflects that, stops individuals deciding themselves. And Rebecca talked about culture being top down, and I absolutely agree with that in terms of setting that organisational culture. I don't know if either of you want to comment or got anything else to say, if we've covered all of that off.
I absolutely agree with that. The only thing with the way that the question is phrased is to tell, how do you tell somebody who feels that they have been sexually harassed that actually this perpetrator has certain peculiarities, and that's why we're going to say that this is okay. And I don't think under any circumstances that's all right. So I think we have to think about the person who is making the allegations here.
Thanks, Rebecca. I'm just going to zip back to a holiday pay question. Actually, it's quite a hard one. So it's about term time only workers, and to what extent you prorate the holiday entitlement in their departure year and the leave that they are joining. So the working time regulations do permit you to prorate holiday based on the first year and the last year, based on the number of working weeks in a year. So that's the general legal principle. In terms of how it happens in practice, I think schools generally do two things. Some simply accrue pay and holiday day to day based on calendar days. So then essentially you would work out someone's annualized salary based on their working weeks, the holiday weeks, and they get the same amount all year round, irrespective of when they join. But you're right, when they leave, you just need to do a sense check that as a matter of fact, they have had the statutory number of weeks prorated up until their departure date, to ensure that they have had their weeks off with pay under the regulations. In most cases they will have done, but you might just need to otherwise make them a payment in lieu. Some schools do choose to accrue salary and holiday based on the working weeks, and that would mean then that you would be doing a calculation in year one of how many working weeks and therefore are left of the year, and what's therefore their prorated holiday entitlement, and paying them that in year one. And the same, then doing the sum in reverse on departure. Both are valid, but you do need to make sure that you're consistent and clear, and all your contractual documentation is clear as well. We tend to take the former approach, that it's just an annualised contract accrues day to day. That's probably the simpler way, but both are fine as long as you're consistent and clear. And so either Jo or Rebecca on this. Social media checks are done as part of recruitment, and we know that we do need to do those online checks now. But is there a sort of positive duty, or what should employers be doing to monitor staff social media accounts, particularly if they're harmful?
I don't think there is a positive duty to be monitoring. I think, in fact, it could be seen as sort of an invasion of privacy, and you need to be careful in that regard. with the online checks when you're recruiting, you're looking to make sure someone's suitable and not a dangerous influence or harmful in the workplace. But in terms of your existing staff, once you've recruited them, if you're getting reports in that social media activity is a concern for people, then obviously that's something to investigate. But again, it's looking at what beliefs or anything else might be motivating those comments, what impact it has on the school, acting proportionately in response to it. But sort of trawling staff's social media presence isn't likely to be something that's popular or necessary, and having a good social media policy in place, setting the expectation of what you expect staff to do online is probably the proactive thing that you should be doing, and probably most of you have that in place already.
I agree, and I think if people have got concerns, they bring them to your attention, and that's the way to deal with it. Rebecca, there's a very last question which we'll finish off because we're bang on time. I don't know the answer to it. If an employee asks for carers leave for a parent, but that parent isn't in the same country, does carers leave still apply?
So I'm just looking it up now. Actually, I can't see anything on first look that says it doesn't apply.
No.
And in fact, it really the only thing it's other areas of this that might be helpful here. So the care has to be because of the person's the dependent's old age. So if you've got a younger member of staff wanting to go and visit their parents, the parent has to be of old age and dependent on them. Interestingly, there is nothing in this that says that they have to provide evidence of their dependents' care needs at all, but there doesn't seem to be anything preventing. Now, you are able to refuse a request if you're saying that there's going to be a disruption to the organisation, so during term time, but you must agree another date within 1 month of the requested date, and put the reason for the delay and the new date to them within 7 days of that original request. But I can't see anything stopping somebody from taking that week for to go and visit a parent abroad.
And of course it could, yeah, you're right, they could use it to go on holiday essentially or go overseas, but as well, of course, in terms of the support that might be needed, it could be Zoom meeting, it could be doing some research about care providers, it could be Zoom meetings with care professionals and things like that, and then it wouldn't matter where the person lives. So I can't see that could be a condition. Actually, as you say, it's the purpose of the leaves that's the critical thing, isn't it? Really.
Absolutely.
Oh, have we covered everything? I think we have, and we're just bang on time. So thanks so much to you all for joining us and for all your questions. It always makes it interesting. We covered an awful lot in a rapid time. So if there is anything that we haven't managed to cover or you still need clarification on, please do contact Jo, Rebecca, or myself, and hope to see you all again soon.